Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. One thing that fascinates me that I'm not actually any good at is lockpicking, lock bypassing, all of that sort of thing. Now, I can't actually practice this to get good at it because Alberta, where I live, bans lockpicking tools. But this is something that I find really interesting. How do people do this? What makes something secure? So, with that in mind, I saw a case and it just really grabbed my attention. And that is this case here, Proven Industries Incorporated versus Trevor McNally. Now, this is a case about a lock company that is very upset with somebody who breaks into locks. Let's find out why. Well, I can give you the brief summary, which is that Mr. McNally posted a video suggesting that it's really easy to bypass one of Proven Industries' locks, and Proven Industries got really mad. They don't like this at all. All right. Verified complaint for damages and demand for jury trial. We're going to go through this in depth in its entirety, and I'm also going to have some other comments on the merits of the case as well. So, plaintiff, Proven Industries, by and through their undersigned counsel, hereby file this complaint against defendant Trevor McNally and alleges the following. So, let's see what they say. Introduction. This is an action for 1. Copyright infringement, 2. Defamation by implication, 3. False advertising under the Lanham Act, 4. Violation of the Florida Deceptive and Unfair Trade Practices Act, FDUPTA, 5. Tortious interference with business relationships, 6. Unjust enrichment, 7. Civil conspiracy, and 8. Trade libel under Florida law. Each cause of action is based on a distinct legal theory and seeks separate and non-duplicative relief arising from different forms of harm caused by defendant's conduct. Now, as we're going to see, a lot of this comes down to hurt feelings, at least in my view, because I think their claims have some issues that we're going to talk about, but yeah, really, this seems to me that they just don't like his videos, and we'll talk about why. So McNally published and widely distributed a misleading and defamatory video purporting to demonstrate a vulnerability in Proven's proprietary lock product. The McNally video used portions of Proven's copyrighted content without authorization, falsely depicted the product as ineffective, and resulted in reputational harm, lost sales, and increased marketing costs to Proven. So we'll talk a little bit about this video. I was going to include the video, or at least portions of it, in this video here, but it appears that it's been taken down by copyright claims on every platform that I could look at. So I can't do it, but I did see it before it went down, and so we can describe it, and they will in this lawsuit as well. So McNally published a video on multiple social media platforms, including YouTube, Instagram, TikTok, and Facebook. As the date of filing, McNally has over 3.5 million YouTube subscribers, 500,000 Instagram followers, 2.5 million TikTok followers, and 250,000 Facebook followers. So that's a lot of people. By contrast, I have way less than that. On information and belief, McNally is affiliated with and/or an agent of Covert Instruments, hereinafter Covert, a company that sells lockpicking tools. McNally lists Covert's website on his social media pages, and Covert Instruments' website features McNally and benefits from the misleading content McNally produces. Note, this is allegations, right? At this point, nothing has been proven. This is what Proven Industries has to say. That's going to be really annoying. Proven Industries, we're just going to have to run with it, but it is going to annoy me as we go through. McNally published the video in a manner that intentionally targeted and caused foreseeable harm to Proven Industries in the Middle District of Florida. Although McNally did not film the video in Florida, McNally committed intentional torts, including defamation by implication, copyright infringement, and unfair trade practices, knowing that Proven, a Florida-based company, would suffer reputational and commercial injury in this district. Okay, so we're going to skip over jurisdiction and venue, which is basically where the suit should happen because it's gonna be a bit boring. Parties: Proven Industry is a Florida corporation. Trevor McNally is an individual who lives in Virginia. And Trevor McNally maintains an online presence for commercial purposes under the user display name McNally Official. Okay, now we're going to get into the factual allegations. Plaintiff, Proven Industries Incorporated, is the sole author and copyright owner of a video titled, "You Guys Keep Saying You Can Easily Break Off Our Latchpin Lock," the Proven video. Now, I haven't watched the original of this because it sounds like a marketing video, and I can see ads everywhere, and I don't want to, so I don't really seek out additional advertising. But the Proven video was completed and first published on March 3rd, 2025. The Proven video was uploaded to plaintiff's official YouTube Shorts account, its TikTok account, its Instagram account, and its Facebook account on March 3rd, 2025. The Proven video consists entirely of original audiovisual content created by plaintiff as a work made for hire and includes original cinematography, visual effects, product demonstration, branding, scripting, and editing. The Proven video is registered with the United States Copyright Office under registration blah. A true and correct copy of the certificate of registration is attached as Exhibit A. Cool. Registered April 7th. And they say defendant extracted, reproduced, and republished a portion of the Proven video without authorization. Now, I've watched the video, and my take is that they did so under fair use. So let's see if they've got a fair use analysis in here. McNally published the subject video, the McNally video, on April 3rd, 2025. The McNally video was uploaded to McNally's YouTube Shorts, TikTok, Instagram, and Facebook accounts. The video is accessible from devices located within the Middle District of Florida at the following URLs, and they provide them, except I think they've all been hit with takedowns, so yeah. The McNally video incorporates an exact copy of excerpts of the Proven video at its outset and uses it without transformation or commentary, except to frame it for ridicule. Now, this is kind of funny because they're like, there's no commentary except to ridicule it, which ridicule would be a form of commentary. I mean, it's criticism. So, they couldn't really go a whole sentence without undermining their claim here. Spectacular. Attached in Exhibit B is a composite of still images of the McNally video showing that McNally copied exact portions of the Proven video. Shown directly below is a first representative still image of the McNally video showing that McNally made an exact copy of excerpts of the Proven video. So this is Proven Industries, and except this one is off of the McNally thing. So, all right. As shown in the page directly above, the McNally video published by McNally begins with the audio and visual work of the Proven video. Shown directly below is a side-by-side comparison that serves as a representative example of how the McNally video includes an exact reproduction of the Proven video. And so here we go. They look the same, except the McNally one for some reason looks better. I don't know why they put one of vastly lower resolution for their own video, but that's a choice. Okay. So, as shown directly above, the image on the left is a frame from the original Proven video published by plaintiff, and the image on the right is a corresponding frame from the McNally video published by defendant. The closed captioning of the audio is the same on both still images, reciting, "Today I'm going to prove." The images are nearly identical in content, showing the same background, subject, gesture, light. I don't know why they're going through this. It's pretty clear that the McNally video begins with a portion of the Proven video. So when they say, they're nearly identical in content, showing the same background, subject, gesture, lighting, it's the same. Just say it's the same video. So the McNally video replicates the exact moment from the Proven video, including the same individual motion and visual sequence. The juxtaposition of these frames shows the defendant copied and republished a portion of plaintiff's original copyrighted video verbatim and without transformation, modification, or commentary, except that the rest of the video is to comment on the first bit. Now, let's talk about what the video is. Well, I guess they're going to describe it a little more, so we'll let them describe it a little further. They leave some things out, though, and those things I think are kind of relevant. So approximately 2 seconds into the McNally video, the footage shifts to a point-of-view perspective in which defendant is shown watching the proven video on a mobile device. The proven video is visibly displayed on the screen, and its original audio is clearly audible within the McNally video. Shown directly below is a second representative still image of the McNally video. So there he is, watching the video on a cell phone. Okay. So the portion of the proven video the defendant copied, as shown on McNally's phone in the still image of the video shown directly above on the preceding page, is used by McNally as a visual and thematic springboard for defendant's performance, and was not shared via embed, remix, or other platform-native features. The reason why that's relevant is that often when you upload, they require you to give a license that allows for the embed, remix, etc. So, the first approximately 16 seconds of the McNally video consist of spliced excerpts taken directly from the proven video. These excerpts include both audio and visual and audio elements, and were arranged by defendant without transformation, commentary, or attribution. Although the excerpts are non-continuous, they collectively depict key portions of the proven video, including the company's logo, product description, demonstration footage, and an image of a proven employee. The McNally video, with its editing, timing, and context, gives consumers the false or at least misleading impression that shimming Proven's lock is mere child's play. Remainder of page left intentionally blank. They probably should have just done that for all the pages, but... In the McNally video, McNally appears swinging his legs and sipping from an apple juice box, conveying to the purchasing public that bypassing plaintiff's lock is simple, trivial, and even comical. Shown directly below is a third representative still image of the McNally video, showing McNally drinking from and shaking a juice box, all while swinging his legs and displaying the proven video on a mobile device. The audio from the proven video was not playing out of the mobile device, rather was extracted from the proven video and played over the McNally video so that it could be clearly heard by viewers. What they leave out here, and what I think is actually kind of significant, is they leave out where there's a comment that is actually listed from Proven that basically says that McNally, it's basically a call out. Now I can't quote the exact text because they've taken the videos down, but McNally includes a sort of quote or a comment from Proven video saying basically that McNally doesn't test hard locks and it basically says that he's kind of crap at his job and essentially challenges him. Now, what do you expect is going to happen next when a lock company throws down the gauntlet at a guy who picks locks? Well, you can do the math on this one. It's not super hard. So the tone, posture, and so the video, the way it begins is it shows, Proven Industries talking about just how great their lock is and so forth. And then it has people trying to get into it with like a sledgehammer and a set of bolt cutters and finding that to be difficult. And then that little clip sort of boasting or challenging or that, quote. And yeah. And then it's got McNally proceeding to open the thing with a pop can shim. So we'll talk about shimming as we go here, but we'll jump back to the case because we're going to go through this in its entirety. We're also going to talk a little bit about an injunction request that they filed, because that's a whole thing too. So the tone, posture, and use of the juice box prop and childish leg swinging that McNally orchestrated in the McNally video was intentional to diminish the perceived seriousness of Proven Industries as a professional manufacturer and falsely imply that the company markets products that are unserious, insecure, or not worthy of consumer trust. They're making fun of me. That's really what that comes down to. The lockpicking sequence is edited to appear as a single, continuous 12-second event. Visual inconsistencies, including changes in the shim's shape, hand positioning, and lighting, indicate the footage was edited or reshot and spliced to present a simplified narrative. Now, what they're accusing him of here is actually sort of a major party foul within the sort of lock sport, lock picking community, because people in that community generally are expected to, like when they're posting videos, to show them as one continuous video so that there are no edits, there are no cuts, just to show, how well or how poorly they actually did. So essentially they're saying you cheated, and they're going to continue to make sort of similar allegations. But what's their evidence? Well, their evidence is actually pretty garbage in my view, but we'll go over it. Shown directly below is a fourth representative still image taken from the McNally video at approximately the 19-20-second mark, which depicts the first appearance of the shim used by McNally in McNally's lockpicking demonstration. So there you go. You can see the shim. It's literally a pop can, sort of cut up into strips and with a sort of hook shape on it. We're going to talk about the shimming in a little bit there. So, and the tagline for the video is $130 lock bypassed with can. It is quite an expensive lock. So shown directly below is a fifth representative still image taken from the McNally video at approximately the 30-second mark, which depicts a second appearance of the shim used by McNally in McNally's lockpicking demonstration. So you can see the shim, but it appears to be at a different angle. So they're saying it must be a different shim because it's at a different angle, and maybe it's been stretched or something by being used to pick the lock. I don't know. They say that it's a different shim, but a comparison between the first application of the shim and its second appearance in the McNally video reveals that the cutout or notch in the shim appears to differ in size between the two shots, suggesting that different shims were used or that the footage was edited between attempts. I couldn't see any edit indications when I watched it, but I don't have the video to go through, so yeah. This visual inconsistency supports the inference that the McNally video was not filmed in a single continuous take and was edited to conceal failed or repeated attempts at bypassing the lock. Now, this doesn't even make sense, because why wouldn't they just, re-record the video? It's not hard, right? So, attached in Exhibit C is a composite of additional still images taken from the McNally video showing discrepancies in the McNally video, which are indicative of misleading editorial practices by McNally. So, yeah, this is going to be an issue at trial, but they say you edited this. While the shim is briefly visible in the McNally video, defendant failed to disclose that successfully bypassing the lock required prior disassembly of the product to examine its internal components, including the position of the plunger, and to manufacture a custom fit shim with precise notch dimensions. Okay, so let's talk about this. They're saying, hey, in order to get through our lock, you have to have some prior knowledge by disassembling it. The problem is that once one person anywhere buys a lock, they can disassemble it. And they can learn this. And in theory, your lock needs to be secure against somebody who knows how it works. Because once one person figures out how to make a shim for it, well, pretty soon everybody will know. All it'll take is some meth addict out there to figure it out and decide they like stealing trailers. And they'll tell their friends, and their friends will tell their friends. And pretty soon, if you have one of these things, people are driving around looking for them and breaking into them. This is how vulnerability sort of end up spreading in the wild. So I don't find that this is actually this is not a good defense. We were relying on security by obscurity. Nobody could possibly have known how our locks work on the inside. Yeah, that's not impressive. Sorry. That doesn't fill me with joy here. Yeah. This omitted context misleadingly suggests that the bypass could be performed easily without specialized knowledge, preparation, or internal measurement. Now, we'll talk a little bit about just how much you need to do internal measurement, because I did a little experiment. We'll talk about that real soon. Although defendant makes no verbal statements in the McNally video, the video communicates materially false and misleading messages through its visual narrative, editing choices, tones, and omissions. Specifically, the McNally video falsely implies that plaintiff's lock product can be easily and trivially bypassed by an unskilled person in a matter of seconds using basic tools without any prior disassembly or technical preparation. Now, I bought one of these locks, and I can tell you I did disassemble it. I had a look at it. But I didn't really learn anything from it. I just instead relied on sort of watching the McNally video and getting a rough impression of what I was supposed to do. Now, I have access to something that Trevor McNally doesn't. I've got a secret advantage over him, which is I have access to an unskilled person. That's me. I think McNally has a problem on that front because he's a highly skilled person. So, yeah. I'll tell you a little bit more in a moment here. The use of juvenile imagery, such as sipping from a juice box while casually applying the shim, reinforces the misleading impression that the lock is inherently insecure and marketed deceptively, all of which is implied without any express claim being made. Okay. All right. I bought this lock, and you can see it says proven and then something, because it wasn't manufactured very well. I think it's supposed to say industries at the bottom, but the printing at the bottom doesn't actually come through. Now, what I was going to do for this video, and now, as I mentioned, I'm not good at picking locks. I'm not good at anything. What I was going to do is sit in the backyard with like a folding chair and a juice box, and I was going to shim this open. But first, I was going to practice so that I could actually, try to do that. And that's where I ran into a problem. Because when I tried it, I could not replicate McNally's attack. I made this shim, and I made it sort of double-sided. And the first side, you can see it tore. So now you might think, oh, well, that says McNally is wrong because the attack didn't work. Except here's the problem. Here is the lock post me trying to get into it. And you'll notice it does this. And it does that even if you turn the key, you try to lock it, whatever you do, it's in a fail open state. So the lock is broken in a way that results in it opening. Now, I actually already took this apart to see what happened, but I'm going to take it apart again to show you guys. Now, it's got this little screw on the side here. Now, it doesn't... I was actually quite stunned when I had a look at the insides of this thing. So, here we go. The inside is just kind of an inside, although it's got a little... it's mostly a cylinder, but it's got a little cutout in the center in there for the plunger to sit into. Now I want to show you what happened because it's kind of funny. So I got my shim and it ended up somehow going into this channel, and it actually has wedged the plunger shut. It's wedged the plunger down. So this thing has failed into a state where it's failed open, and it's failed into an unlocked state. Now I'm gonna take it apart a little, if I can, in order to I'm just trying to sort of improvise some tools here to see if I can actually get this thing apart and out to try to I'm trying to pull this foil out of it. But yeah, the foil is wedged in there. It's good and stuck. I'm just trying to see, does this thing come out? It's got to disassemble somehow. Oh, here we go. So pulling this apart. There we go. I got my foil out. Where'd that go? It fell down here somewhere. Yeah, that's the foil that got stuck in the can end. All right. So we'll reassemble this thing. And I am just kind of stunned at just how dumb this design is, because it's very dumb. And yeah. So this is the design, and it has this little plunger thing here, and that plunger engages with a track here. And so the way the shim attack works on this plunger thing is that the little piece of metal hooks onto this and depresses it, and then allows for the whole thing to come out. Or in my case, it just gets in under there and wedges it real good and just kind of screws the lock up. But, so this thing fits in here. This is a really bad design. This is actually really awful. And the funny thing is that you could probably fix this design really quickly. And what I mean by that in terms of like a quick fix, I'm not sure if you can see this very well, but you can see that channel there. If they actually, for instance, put a, if they put like a, you know, a further channel in it, and so something could sit behind this, you know, sit like right here and block this plunger from being attacked with a shim, well, it wouldn't be perfect by a long shot, but it would absolutely increase the security. They could, for instance, also put a little lock in this thing that prevented it from moving unless there's a key inserted. All of that would help, but no. This thing very much resembles the security level that you might find on like a bathroom door built into a very heavy housing. So I'm kind of shocked that this was a product that's on the market and that they're super impressed by. Now, maybe they'll sue me for my sort of examination of this thing, but I am an idiot with respect to breaking into things. And just based on having watched a TikTok video, I was able to not replicate the nice clean open that Mr. McNally did, but I was able to break this in a way that it just opened real easy. Yeah, it's a bad product. It's not like I just my opinion of this thing is that it's just not good. And, you know, this is not me as a locksmithing, lock sport expert, but if I can get into this thing, then who can't? So I was very much not impressed by this lock. Yeah, I couldn't do my little, you know, the sipping from a juice box thing, but I was kind of stunned at how I managed to, you know, and to be fair, as they said, I'd taken this thing apart and looked at it at first beforehand, but I didn't need to do that. The looking through it beforehand wasn't like a necessary step. I just tried shimming it, and it failed catastrophically to that shim attack. So, yeah, this is not a great product. I'll also just note, it's also not terrifically great just to operate in its intended fashion. I actually found it to be kind of annoying for opening legitimately. So, yeah, I actually might have had an easier time opening it with the can than I am with. Oh, there we go, with the legitimate opening. Yeah, okay, so that is just for discussion of they're talking about how super great this is. The infringing video begins with excerpts from plaintiff's professionally produced promotional video showing its branded product demonstration, including voiceover descriptions and visuals of the product in use. The video then abruptly shifts to defendant in a childlike persona, sipping from a juice box and casually applying a shim to the lock. The video omits any reference to preparation, tooling, or disassembly. The tooling being making something out of a pop can? And presents the lock bypass as effortless and trivial. The overall presentation implies to the average viewer that plaintiff's product lacks meaningful security and that plaintiff misrepresents its functionality to the public. Now, here's the thing, is if the lock is vulnerable to somebody who can use a particular shim made out of a pop can, even if it requires somebody who, or to figure out the shim originally, even if that requires somebody who's actually disassembled the lock, that doesn't mean it's a secure product. In fact, quite the opposite. Because once the shim design is out there and somebody can get it from watching the videos and so forth, the lock isn't very good anymore, right? So, yeah. Defendant's reuse of the proven video was not authorized by plaintiff and was not confined to any fair use or statutory exemption. Are you going to actually do a fair use analysis, or are you just going to say no fair use? The portion of the proven video copied by defendant was not used for commentary, criticism, education, or news reporting, but rather for commercial entertainment and mockery. So they say it's not used for criticism, but it is used for mockery, and mockery is a form of criticism, and a form of commentary. It's really nice when people in pleadings can get through an entire sentence before contradicting each other themselves. Yeah, defendant's use was not transformative. The excerpt was copied, so they are doing a fair use analysis, sort of. Was not transformative. The excerpt was copied verbatim and used to mischaracterize and target plaintiff's product rather than to provide any genuine analysis or new expressive purpose. Well, isn't that a new expressive purpose? Because your purpose is to say that your product is great. And their purpose is to say, no, your video is wrong and that your product actually kind of sucks. That's a new expressive purpose. So you're not really helping your case here, in my view. The reproduction of plaintiff's copyrighted material was not necessary to convey any legitimate message. Is it not a legitimate message to say that your lock might kind of suck? And was instead included to improperly attract attention, ridicule plaintiff, and frame the lock product as insecure and trivial. Well, I mean, ridiculing plaintiff, maybe you can say that's not a legitimate message. I think it is, because, the First Amendment and freedom of speech allows you to mock people, but saying that your lock product is insecure actually is an important, legitimate message. We'll talk about that a little later as we go, because it's a big, important issue. Defendant's use of the proven video competed with plaintiff's original publication on the same social media platforms, diverted traffic and engagement, and impaired the market value and licensing potential of the original work and advertised product. The original work is an advertisement. And so nobody wants it. Nobody wants an advertisement. The reason why McNally's video was doing so much better is because it's actually entertaining and it actually provides value to a person who watches it, as opposed to an advertising video, which tends not to. Now, you'll note here that they say the market value and the licensing potential of the original work and the advertised product. Copyright law is concerned about whether or not it's impeding the value, like the market for the original work, but not concerned about whether it's impacting the market for the advertised product. That's outside of it. So on YouTube, defendants' use exceeded the limited license available to users, which permits only playback or embedding. McNally created a separate monetized derivative work from plaintiff's copyrighted content. So basically they're saying they're not under a license from YouTube, Facebook, Instagram, TikTok, etc. We'll skip over this because really their argument is going to be fair use. So McNally warranted to TikTok that McNally owned or had rights to all content in the McNally video as required by TikTok's terms of service. That warranty was false. That's not something you can claim for. That's something TikTok might be able to take up as an issue, but that's not your problem. That's TikTok's problem. The McNally video contains no disclaimers, limitations, or clarifications about the video's context, setup, or repeatability under normal conditions. I mean, I couldn't repeat it. I could just do worse to the lock. Yeah. As of April 17th, 2025, the McNally video received over 9.6 million views, 435,000 likes, and 6,000 comments on YouTube Shorts. On Instagram, 500,000 likes, 3,000 comments, and 20,000 shares. On TikTok, over 3 million views, 300,000 likes, nearly 2,000 comments, and 17,000 saves. And on Facebook, it was posted to his account. That's all they can say. Okay, cool. Following publication, plaintiff received public comments and customer inquiries referencing the McNally video and expressing concern or doubt about the integrity of plaintiff's product. This is not surprising. On information and belief, plaintiff lost business opportunities with commercial customers who viewed the McNally video and opted not to purchase or proceed with intended transactions. This is actually the public service that McNally is doing, because if you're looking to buy a lock, one of the things you want out of the lock is security. And in fact, Proven Industries knows this. That's why they made the video going, you can't break into this thing. But if it turns out you can, then that is of interest to the public. So, plaintiff incurred reputational damage, customer confusion, and the need for emergency marketing and advertising techniques and procedures to mitigate the harm caused by the McNally video. And then you launched a lawsuit in order to maximize the harm through the Streisand effect. That was not a smart move. Now you'll note here what they don't have, which is emergency engineering, because maybe they should be trying to figure out a way to fix this so that it doesn't have the problem. And ideally something where they can like ship a fix to customers and be like, sorry, our bad, you know, here's something to fix it. But we don't have that. That's not something they seem to be doing. Okay. McNally monetizes his content across platforms and links to Covert Instruments, a company that sells lockpicking tools, across his social media profiles. Now, I couldn't find a tool there for bypassing this. I looked at their webpage. Maybe I missed it. I can't say I did an exhaustive search, but I didn't see anything like that advertised. On information and belief, McNally receives compensation or other commercial benefits from his publication of the McNally video. That would surprise me if it wasn't true. On information and belief, McNally receives compensation or other commercial benefits from his affiliation with Covert Instruments. Also, I would be surprised if that wasn't true, because, I mean, when you work for a company, typically they pay you. That is what work is about. On information and belief, McNally coordinated with individuals at or affiliated with Covert Instruments to produce and publish the McNally video. Maybe, I don't know. Following publication of the McNally video, McNally's followers began engaging in a coordinated pattern of online harassment targeting plaintiff. Coordinated? No, I don't. I would love to see some evidence of that, because I'm betting it's just people saw it and they decided to start making fun of you. But I don't think there's anybody coordinating it. Certainly not McNally, or you'd allege that. Who's coordinating this? Numerous of McNally's followers have commented on plaintiff's social media posts with disparaging, threatening, or mocking language, often echoing the themes, imagery, and misleading implications conveyed by the McNally video, as illustrated by representative examples attached as Exhibit D, i.e., people are making fun of us a lot, and sometimes they make references to, like, juice boxes and stuff like that. Plaintiffs' customer service channels received abusive or misleading messages from individuals who identified themselves as viewers of the McNally video. Now, I'm just wondering what all they count as abusive or misleading. I called them up and I asked them if they had a comment, and they were just like, no, thank you, goodbye, click. So, I mean, they were polite about it when they said, no, thank you, and then click, but they had no comment. Numerous false or negative online reviews and comments referencing McNally's video appeared across platforms shortly after its publication, suggesting a coordinated response from McNally's audience. It does not suggest a coordinated response. It just suggests that a lot of people came to the same opinion because they viewed content. But coordinated means that there's somebody coordinating it, and that makes no sense. Like, it just, that's crazy talk. Unless you've got some actual evidence of that. On information and belief, McNally knew or should have known that publishing the McNally video to his audience of millions would incite a wave of targeted hostility toward plaintiff located in the Middle District of Florida. This is a wonderful argument, because it's like, listen, you've got a First Amendment right to have an opinion, Mr. McNally, but not if people will listen to it. Not if there's lots of people who will care about your opinion. Yeah, I don't think that one's gonna fly, but good try, I guess. McNally's substantial social media reach, over 3.5 million YouTube subscribers, the same numbers, amplified the harm and enabled large-scale reputational injury. The conduct of McNally's followers, acting in concert and with knowledge of the McNally video's purpose, contributed directly to the harm suffered by plaintiff and was foreseeable, encouraged, and ratified by McNally's platform and silence. So not something he said, but something he didn't say? Good luck landing that claim. The timing, content, and branding of the McNally video reflect a common plan to disparage plaintiff and promote covert industries' affiliated products and services. I mean, it's not like they sell locks there. They only sell lock bypassing stuff. So it's not like your competitors exactly. McNally's conduct was part of a broader scheme to harm plaintiff's business reputation and drive consumer attention to alternative products or services affiliated. Again, I don't think he makes competing products. But further, you left out that you specifically called him out. You were like, this guy sucks and he'll never try to break into our product because our product is awesome and he's a wanker. So, like, we picked a fight with the guy and now we regret it. So, McNally acted with actual malice or with reckless disregard for the truth by knowingly presenting a misleading demonstration and suppressing key context. McNally failed to exercise reasonable care or competence in assessing and representing plaintiff's product, despite presenting himself as an expert. Now, I just want to note, I am not presenting myself as an expert. I am repeatedly presenting myself as an idiot in this particular sphere, but I was able to get into this. Yeah. McNally's use of the proven video was not incidental, transformative, or justified. It was commercial, deliberate, and intended to attract viewership and revenue by disparaging plaintiff's product. McNally unjustly retained commercial benefits from this conduct, including increased engagement, monetization, promotional clicks, and affiliate traffic. Defendant's conduct was not a one-time error in judgment. Oh, we'll see. He's got lots of... they're really upset, and especially because of the not a one-time thing. But rather a calculated effort to ridicule plaintiff's product and brand before a massive online audience, knowing that doing so would spark reputational harm and commercial loss. Thing is that sometimes you don't deserve the reputation you have, and people are allowed to say that. Defendant published the McNally video with actual knowledge that its visual editing, omissions, and mock tone would lead viewers to believe that plaintiff's lock product was ineffective and deceptively marketed. I don't know how it's marketed, but I don't think it's a great product. Yeah. Despite defendant knowing that bypassing the lock required specialized preparation and manipulation not disclosed to the viewer. Defendant acted with deliberate indifference to the truth, including by failing to disclose that the lock was disassembled and studied in advance, which I consider completely irrelevant here, but they think is a big deal. That a custom shim was designed to defeat it, out of a pop can, and that the lock's bypass was staged and edited for effect. We'll see. I don't think it was, but we'll see. Rather than publish fair commentary or criticism, defendants selected and copied branded portions of plaintiff's copyrighted video, stripped of context, and presented them with mocking theatrics and edited staging for the deliberate purpose of humiliating plaintiff and falsely implying its product is insecure. You know what's going to happen if this goes to trial? They're probably going to break into this thing. They might even teach the jurors how to do it. At which point the jurors will be like, oh, right, we can learn to do this with a pop can. Cool. See, now a better content creator would edit that out, and if I remember to do it, I will, but it's probably going to be in the final version. Defendant is a self-described lock expert with over 3.5 million YouTube subscribers and commercial ties to Covert Instruments, a company that markets lockpicking tools. Defendant was fully aware of the weight his endorsement or criticism carries and exploited that authority to discredit plaintiff's product for financial gain. Again, you called him out. You basically threw down the gauntlet and he gauntleted. Defendant failed to issue any clarification, disclaimer, or correction despite knowing that his followers were using the McNally video to launch disparaging, harassing, and defamatory attacks on plaintiff through coordinated online messaging. The coordinated thing they keep saying it makes no sense, including threats, false reviews, and customer service abuse. On information and belief, defendant collaborated with individuals affiliated with Covert Instruments in developing, editing, and disseminating the McNally video in furtherance of a commercial scheme to divert attention from plaintiff's products to competing tools or services. What's the competing does Covert Instruments market any lock? So how's that competition, right? It's like saying that the person who manufactures chainsaws is in competition with a tree planting firm. No, that makes no sense. Defendant monetized the McNally video, promoted affiliated commercial links alongside it, and knowingly submitted false licensing representations to social media platforms to obtain algorithmic amplification and increased monetization, despite knowing that he lacked rights to plaintiff's copyrighted content. Having seen the video, my assessment is that it's probably fair use, but yeah. So here we go. The counts. Count 1, copyright infringement. They reallege all of the above. They say it arises from unauthorized reproduction and public display of the video. They say they own a valid and registered copyright in the proven video. That's important if they want to get statutory damages, because they have to have a registered copyright. Defendant copied, reproduced, publicly displayed, and distributed substantial portions of the proven video without authorization, including on all the platforms. Not authorized by license, not excused by fair use, and was done for commercial purposes. They say defendant acted willfully and in reckless disregard of plaintiff's exclusive rights. Defendant's infringement was willful because McNally knowingly uploaded plaintiff's copyrighted content to social media platforms, including all the platforms, under the guise that McNally either owned the content or had permission to distribute it, a prerequisite under each platform's terms of service. That argument doesn't really work for me, but okay. Defendant's false certifications, I will give them points. I haven't seen a lot of glaring typos or anything. Enabled him to gain preferential algorithmic exposure. How does he get preferential exposure? Monetization and viral reach using plaintiff's content. It wasn't your content that was making that video work. Just, further demonstrating the commercial motive and knowing violation of plaintiff's rights. So, as a result, they've suffered damages, including but not limited to loss of control over its intellectual property, lost licensing opportunities. Who the hell was going to license your advertising video? Reputational harm and diminution in the value of the copyrighted work. It was an advertising video. What was the value of it? All right. Count 2, defamation by implication. This count arises from defendant's publication of the McNally video, which through tone, editing, omission, and visual presentation falsely implied to viewers that plaintiff's business was dishonest or incompetent, and that plaintiff's lock product was inherently untrustworthy. Yeah, it's a move to put this in front of the court because the court's going to make a determination, and I don't think this thing's going to hold up. Although the McNally video did not explicitly state that plaintiff committed fraud or sold a defective product, I mean, here's the thing. Lots of locks get made that turn out to suck. It's a whole sphere of things. The better thing to do if somebody, if an expert determines that your lock sucks, is to de-suckify it, remove the suck. In fact, if I was a company making locks, somebody like McNally is exactly who I'd want to reach out to and hire and basically say, hey, here's an NDA, and here is our lock, and here is, a check, and can you break into our lock? Can you determine if this lock is secure? And if they come back and say, we can't break into it, you say, cool, that's excellent. And if they say, we can break into it, you say, how do we fix that? How do we make it, so that this is secure? That would be the better way to go. So defendant juxtaposed facts and edited content in a way that conveyed a defamatory implication, namely that plaintiff markets a security device that is ineffective, deceptively advertised, and easy to defeat even by an unskilled user. It's me, it's the unskilled user, and I mean, I didn't try a lot. I had a few efforts of futzing around with the shim, not getting anywhere, and then I'm like, all right, and pull, because in the video he pulls the shim out and everything comes out nicely, and I tried and it ripped and I didn't get my shim back, but then the lock just was wrecked because it was just able to open full stop. So yeah, defendant's McNally's video downplays the difficulty of shimming Proven's lock by making it seem as if shimming the lock is mere child's play. By having the actor sip apple juice from an apple juice box and swing his legs in a childlike manner. In a childlike manner, okay. I said not a whole lot of proofreading errors, and there we go. All while the actor watches Proven video on a mobile device, which was specifically designed to ridicule plaintiff and to suggest that its product is so flawed that it poses no real security barrier. Now, in the meantime, Proven Industries has done other videos, like going through a bunch of these locks, all one after another. These implications were materially misleading and false, and they were conveyed to millions of viewers across multiple platforms. Defendant acted with actual malice. So actual malice isn't like Mwahaha, I'm evil. Actual malice is that you either knew that what you were saying is not true, or you had, reckless, or you were reckless about it. Now, actual malice includes reckless disregard, but they kind of, yeah. Um, Now, what does it mean to be reckless? Well, in this sort of context, it would mean something like you suspected that what you were saying wasn't true, and you went ahead anyway. So, by presenting the product demonstration out of context, omitting necessary disclosures, such as the use of a custom shim, he actually says that they use a custom shim. It just notes that he made it out of a pop can. Manipulation time or setup, and selectively editing the footage to mislead viewers about the real-world difficulty of compromising the product. Viewers understood the McNally video to imply that plaintiff's product, and by extension plaintiff's company, was disreputable or fraudulent. Well, really, they just say that your product sucks. That doesn't mean that it's fraudulent. It just means that it's a bad product. Come on. Let's be serious here. The implications extended beyond the product itself to cast doubt on plaintiff's honesty, competence, and value as a manufacturer. You know how you actually solve the problems of people having doubt about your honesty, competence, and value as a manufacturer? You fix the thing, you fix the security problem, and you do a recall. That's the way to go. That's how you save your reputation. As a direct and proximate result of these defamatory implications, plaintiff and plaintiff's product reputation suffered reputational injury, public ridicule, diminished trust within the customer base, and measurable economic harm in the form of lost goodwill, canceled transaction, and the need for emergency marketing expenditures. Again, the need is for emergency engineering expenditures. Fix it. Fix it. And maybe the reputational injury and diminished trust is because the product sucks. Like, unsuck your product. I mean, I don't know if I could repeat it or what, but I shouldn't be able to get into your lock with a piece of pop can and very little knowledge. Count 3, false advertising. Plaintiff repeats and realleges all of the above, and they say it arises from their materially false or misleading statements made in commercial promotion that misled consumers and diverted business from plaintiff. These misrepresentations were made in commercial promotion and are likely to influence consumer purchasing decisions. Their false claims about the ease of bypassing the lock were material and deceptive. Their false representations were made in connection with the commercial promotion of alternative products or services affiliated with defendant and/or covert instruments, and therefore directly harmed plaintiff's commercial interests and consumer perception in the marketplace. So they want money. Violation of fiducia. This count arises because the defendant engaged in deceptive and unfair practices in the course of trade and commerce by publishing misleading and materially false representations. It's the same claim, but yeah. Defendant's conduct was likely to mislead reasonable consumers and had the capacity to deceive the public into believing that plaintiff's product was defective, insecure, or easily shimmed, when in fact it was not. Okay. So defendant's actions were not merely opinion or puffery, but constituted factual misrepresentations related to the quality, functionality, and performance of a consumer product. As a direct and proximate result of defendant's deceptive and unfair practices, suffered actual damages, etc. Tortious interference with prospective business relationships. Okay. So this is basically, there's certain rules that prevent you from messing with other people's ongoing business. So as an example, let's imagine that I am selling 10,000 widgets to Bob every year, and somebody who makes a competing widget product goes over to Bob and says, you know, Runkle's widgets are defective. And it turns out my widgets are not defective. And so, you know, I might be able to sue that other person for interfering with the contract that me and Bob have. So plaintiff had valid business relationships with existing and prospective customers, including trailer manufacturers, distributors, and end users. Defendant knew of these relationships or reasonably should have known of them. Defendant intentionally and unjustifiably interfered with these relationships by publishing false, disparaging, and misleading content. Defendant's conduct, including publication of the McNally video and the resulting coordinated activity by his followers, again with the coordinated, interfered not only with plaintiff's customer relationships, but also with plaintiff's advertising efforts and marketing channels, causing reduced ad engagement, increased negative responses to paid placements, and the need for unplanned emergency media spend. Plaintiff lost business and revenue as a result of such interference, including canceled commercial transactions, terminated sales leads, and interruption of planned advertising strategy. All right, unjust enrichment. What does unjust enrichment mean? Well, it means you got money or something and you shouldn't have it. So, for example, let's say me and Bob make a deal and I'm going to sell Bob, gold bars at a set price. And so I deliver the gold bars to Bob and Bob says, I'm not paying you. So now Bob is sitting on a bunch of gold bars and I have no money. Now, I sue Bob both for the contract that I was going to sell him these, but also for unjust enrichment. Because if it turns out that the contract is no good for some reason, maybe Bob was drunk or something at the time, and it wouldn't be a little drunk, it would have been like really drunk to invalidate a contract. Well, if the contract's not valid, I want to have sued in an unjust enrichment because then I can say, Bob's got all this gold and he's not supposed to. He didn't do anything for it, and it's unfair. Make him give the gold back, or give me the money, or something, right? So that's unjust enrichment. So there's lots of different ways to get to an unjust enrichment, but that's an example. So they say this count arises from defendant's unauthorized use and monetization of plaintiff's content and seeks equitable relief, therefore. Defendant misappropriated plaintiff's copyrighted content and used it to generate engagement, revenue, and traffic to his own platforms and affiliate entities. Defendant's enrichment was not limited to monetization or exposure. It was also derived by falsely warranting to social media platforms that McNally had the rights to use plaintiff's copyrighted content, thereby bypassing platform restrictions and gaining algorithmic distribution and user trust that would otherwise have been denied. Defendant's conduct violated the spirit and letter of the limited user licenses granted under the various things, resulting in additional inequitable benefit. I don't know why Proven Industries is trying to litigate YouTube's terms of service with McNally, because that would be an issue for YouTube and McNally to fight over. I'm just trying to figure out how Proven tries to claim they have standing in that particular contractual relationship. But defendant retained a benefit to which McNally was not entitled, and it would be inequitable for defendant to retain that benefit without compensation to plaintiff. So count 7, civil conspiracy. This count arises from a coordinated and intentional effort by defendant acting in concert with third parties, including covert instruments and others, to cause reputational and commercial harm to plaintiff through the production, distribution, and amplification of the McNally video and the resulting wave of disparagement. Are they going to actually get too coordinated here? On information and belief, defendant entered into an agreement or common plan with one or more individuals affiliated at covert instruments to publish a misleading and harmful McNally video targeting plaintiff's lock product with the shared purpose of damaging plaintiff's reputation and market share while promoting covert's lock-picking tools and related products. I suspect that they just wanted to show that your locks sucked because you called them out. The McNally video prominently featured branding, language, and promotional elements tied to covert instruments, including outbound links to Covert's website in the social media bios affiliated with McNally. Covert Instruments' website likewise featured defendant and benefited from the publication. Following publication of the McNally video, defendant's large online following engaged in coordinated, there's that word again. I haven't seen any actual facts to support it yet, but online conduct that included mass commenting on plaintiff's social media, spreading mocking and threatening language, posting negative reviews, and submitting disruptive communications to plaintiff's customer service channels. Where's the coordination? And not just a bunch of people who don't like you. This conduct was foreseeable and encouraged by the tone, messaging, and platform reach of defendant's McNally video. Literally, with the platform reach, they're just saying, hey, he shouldn't have opinions because he's got so many followers. Defendant and Covert Instruments ratified and benefited from the campaign without disavowing or attempting to mitigate the resulting harm to plaintiff. It's not their job to make people like you. The conspiracy's objective was to inflict reputational injury, interfere with plaintiff's business relationships, and suppress commercial demand for plaintiff's products in favor of alternatives promoted by Covert Instruments and affiliated with defendant. As a direct and proximate result of the conspiracy and resulting acts in furtherance of it, plaintiff suffered reputational harm, loss of sales, cancellation of prospective customer relationships, I'm guessing a bunch of people had orders they canceled, and increased in expenditures to restore brand integrity and public trust. This lawsuit ain't helping. I know this lawsuit's already been reported on by several other people, but most of them aren't going to do the deep dive that I will. So, you're welcome. Count 8, trade libel. So, this is going to get a little repetitive, but they say that the performance of their physical product, namely its proprietary trailer lock, as opposed to, plaintiff's brand or reputation. So, false and disparaging statements, they say. Widely disseminated to third parties that portrayed their lock as defective and easily bypassed. Presentation mischaracterized the product's security features and falsely suggested that it could be compromised in seconds using basic tools. These statements and implications were made with malice or with reckless disregard for the truth and without due diligence or technical accuracy. Defendant omitted critical context, including the use of specialized tools, rehearsal time, or manipulated conditions that would not be present in real-world use. These statements were materially false and concerned the product's physical attributes, mechanical performance, and suitability for its advertised use, all of which are provable and verifiable facts. Defendant made these statements publicly, and they were viewed by millions of customers, including prospective customers, industry professionals, and product distributors. As a direct result of these false product-specific claims, plaintiffs suffered special damages, including lost sales, disruption of distribution channels, and harm to product marketability. So they want a jury trial, and they want the following relief. Actual damages and any additional profits of defendant attributable. So they want disgorgement of the profits. Any money McNally made, they want it. An award of statutory damages of up to $150,000 for willful infringement. A permanent injunction prohibiting defendant from further copying, publishing, or distributing the video or any derivative thereof. An award of their full costs and reasonable attorney's fees. So for count 2, defamation by implication. They want money. They want additional money for publication of a video that knowingly or recklessly implied false facts about plaintiff's business integrity. And they want a permanent injunction prohibiting defendant from republishing the defamatory content or further implying that plaintiff engages in dishonest or deceptive business practices. I don't actually think that was alleged. It was just that this product sucks. That isn't to say that you were dishonest or deceptive. It's just you made a product that is not good. False advertising. An award of plaintiff's actual damages and corrective advertising costs. Okay. An award of defendant's profits. Triple damages due to willful and deliberate conduct. So they're saying we get 3 times our damages. permanent injunction for making false or misleading commercial statements about their products, and an order of specific performance requiring defendant to publish a corrective statement on each platform where the where the advertising was distributed. I don't think they're going to get that. To clarify that plaintiff's lock product was not fairly or accurately represented in the McNally video, and to retract any misleading implications about its quality, performance, or security. Okay. Violation of FDUPTA. FDUPTA is not a great thing. So they further want an injunction. So an injunction would prevent them from doing anything in future. They want attorney's fees. They want more money. Unjust enrichment. They want the money that was made. They want that to be turned over. They want restitution. Civil conspiracy. An award of punitive damages to address the willful orchestration and ratification of a coordinated scheme. I don't think they're going to establish coordinated scheme, but yeah. All right, so they want all sorts of stuff. And there are some choices there. Let's go with that. So I don't think this is a very good lawsuit. And yeah. Now, I believe Florida actually has an anti-slap statute, which I expect that we will see McNally attempt to use. And so if McNally is successful in using the anti-slap, then he may be able to get this thrown out and might be able to get his attorney's fees and so forth. So we'll see. I think that this is really just, I mean, this lawsuit to me looks like it's intended to, and again, this is my opinion from reading it, but it looks like it's intended to shut him up rather than intended to, remedy some actual wrong, because I think that the claims with respect to any actual wrong are pretty weak. But we can get into that a little further because they also file another document. We're not going to go through the other document in full detail, but the other document is this: plaintiff's emergency motion for preliminary injunction. So they want an injunction preventing Trevor McNally from infringing their copyrighted video and publishing content that falsely implies Proven's lock products are insecure, trivially bypassed without skill or preparation, and that Proven knowingly misleads customers about the product's security. And the reason why is they say defendant continues to maliciously publish social media videos that falsely imply Proven's locks are easy to unlock without a key and without preparation, expertise, or training, even after Proven filed its verified complaint based on the same assertions. Now, listen, I'm guessing that McNally doesn't actually think your verified complaint is all that good. They probably think that your complaint is some BS, and so they're just putting out videos showing that your product sucks because they don't like you. And because your product might suck. All of defendants' videos employ the common theme of falsely implying Proven's locks are easy to unlock without a key and without expertise or training. So on May 28th, defendant maliciously published his most recent video. This comes one day after Proven's counsel advised defendant's counsel about an email from one of Proven's employees expressing concern for the employee's own safety and job security because of the hundreds of violent, sexual, and threatening messages Proven received because of videos defendant published on the May 23rd and May 25th. So they're saying we're getting a lot of people who are really angry. Well, Proven, I know you didn't ask me for anything, and I'm definitely not your lawyer, but there is better ways to handle this PR disaster than what you're doing. And many of my viewers will be stunned to learn who isn't your lawyer based on what's going on here. So, yeah. Okay, so let's sort of go towards the end of this rather than, pushing through everything because yeah, look at some of the some bits of it at least. So they say um after displaying the copied excerpts of the proven video, part 1 then cuts to the sequence of McNally bypassing the proven lock using a piece of aluminum can. Part 1 omits that McNally had previously inspected the internal mechanism of the lock and fabricated a custom shim specifically for that lock. So, since he published part 1, they've experienced all sorts of harm. At least one prospective buyer directly stated they would not purchase the lock after viewing the video. Proven was forced to disable comments on posts and video product videos due to an influx of mocking and misleading replies, furthering the false narrative that McNally conveyed to the viewers. Again, you could totally manage this in a better way. This is not difficult. As a result of the McNally video, Proven has incurred increased costs in moderating its social media accounts, managing customer service inquiries, and adjusting marketing strategies to combat the video's reach. Moderating your social media accounts is actually entirely the wrong approach. The more you try to suppress people from talking about this, the more they're going to want to talk about it. And that is, it's just one of the sort of failure, things in the world. Now, they also sort of object. They say, McNally shims the proven latch pin lock while it is not in use on a trailer coupling. By failing to attach the lock to a trailer coupling, its intended use, the lock is easier to shim. I mean, if this is your argument, this is pretty weak stuff, right? Pretty weak here. They say in part 4, he continues to omit key details, including prior attempts, inspection of the locks, and the custom preparation of the shims used to bypass said locks. I don't think that's relevant really at all. But let's sort of look at some of what they're looking at here, because they make some claims that I think are pretty ridiculous, and let's talk about that. They say McNally's conduct falls outside the scope of protected commentary and into the realm of commercial exploitation and theft promotion. Theft promotion. Okay. Injunctive relief in this case supports the public interest by holding McNally accountable for his deliberate actions and preserving the integrity and safety of the marketplace. Additionally, public policy weighs against the unregulated dissemination of misleading lockpicking videos that falsely suggest consumer security devices are ineffective when in use. There's going to be some real contradiction in their argument here. States like Florida criminalize the possession of burglary tools, including lockpicking instruments, due to the inherent public risk, tools which McNally promotes. But he sells them out of Virginia, so yeah. The McNally video, created for personal profit, reputational sabotage, and theft promotion, really, serves no public good. The continued spread of deceptive videos purporting to teach lock breaching runs counter to these public safety interests because there's no other legitimate purpose to disseminate these videos other than to promote theft. What? Even platforms like YouTube prohibit content that encourages illegal or dangerous activities, including instructional theft or demonstrations that bypass security systems. No public interest is served by allowing a social media creator to deceptively create videos, misuse a business's content without permission, promote theft and lock bypassing, and promote false implications about said business's product to mislead consumers. So here's the thing. They've been saying that this technique is BS. Like, this guy is falsely saying that you can, that you can easily get into our locks. But they're also saying that his videos are going to promote theft. And if his videos are bullshit, if the videos are a situation where you're unable to, where his technique doesn't work, then it wouldn't be promoting theft, right? Because if he's promoting a technique that doesn't actually open the thing, then nobody can use the shim to steal stuff. But let's say he's pointing out that, let's say he's correct and the shim technique works and you can get into this easily. Well, then there is a very clear public interest in him promoting that knowledge, which is that the consuming public has an interest in not buying a lock that doesn't, that isn't very secure. And so the public would absolutely have an interest in that. That's absolutely a legitimate interest for the public. In the same way that if you discover that a particular car has brakes that fail, that it would absolutely be in the public interest to be like, hey, this causes brakes to fail. This is bad. I don't think their argument is very good here. I'm kind of stunned, actually. So yeah, to sum up, my assessment of this thing, and again, as a security idiot, I was not impressed by this at all. And my attempt to shim it in the McNally method there failed, but failed in a way that still opened the lock. It just didn't open it nicely the way his did. It opened it in a way where it was kind of jammed open. But, I mean, if this was used to protect valuables, that still is a state where people get the valuables. That's a problem. So, I don't think, I think that Proven is behaving in an absolutely idiotic way here. I think that they are damaging their own PR. Whoever is advising them on how to do PR is really awful at it. And quite frankly, they should learn better in a real hurry, because I think that I think there's real potential for this to just keep blowing up in their face until maybe they're just, so their problems are probably fixable. They just need to actually fix them. So yeah, that's the lawsuit. I had some people ask me about it, and once they did, I was like, yes, this is really interesting. And yeah, so I'm going to keep following this one, assuming you guys continue to be interested. But please let me know what you think in the comments section below. Like this video, share it with your friends, subscribe, all the things. I also want to thank my Patreon supporters. I've got a link to the Patreon below, but at the $50 level, Bottle Shock in Oz, Canada's National Firearms Association, the Canadian Coalition for Firearms Rights, the Canadian Shooting Sports Association, PJs Forever, Angela Skelton, Cielo, and at the $20 level, Mark, Lindsay Metcalf, Larry Kalniak, Kyle Fox, Drunkle of the Baileys, Cameron Johnson, Andrew Elsich, and Marvin CZ. Thank you as well to my $10 supporters who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.